I have an extra just in case.
That means you should, because that has been in
Yeah,
it.
no, like I said, nobody would be able to read mine. And then when I got home, I probably wouldn't be able to decipher my own handwriting to even type
The
it.
best you got there. That's very nice.
Well, cross-marketing,
Please?
cross-marketing.
Well, that's of course, there's nothing wrong with that. It's been happening for years. I should have worn my Wolverine hats.
Looks like the heat's on in here.
Hooray.
So hard at this time of year to know what to wear.
Yeah, they go up and down and.
Yeah.
It's cold, and then you get in someplace and it ends up being hotter than I thought it was gonna be.
Okay, well, it's 1 minute after, we're just gonna get started. And, so I'll call the meeting to order, and, if Thad walks in, he'll have a seat right by the door. Could I have a motion to accept the minutes from the last meeting, the October 30th meeting? Any additions or corrections, and if not, a motion to approve? Nick?
That sounded,
Second. All right, Heidi, thank you. The minutes will stand approved as written. And tonight, I'm just gonna kind of review quickly what our process is and what we did the last time. And that is, hi Thad.
Hi.
We just started. Just remember that we're gonna go through 3 articles tonight. They're long, and I think in looking at it, we probably will be able to do the rest of them Thursday night. So we'll have our first reading completed by the end of this week, hopefully. And so we'll go around and read a paragraph. Think in terms of what is the purpose of the section, is it stated clearly, is it current with present practices, and is it needed or necessary? And then if there is a yes to any of that, we make note of that. We do not go into big discussions about it, but we note that that's something we need to come back to, okay? And I think tonight we'll start with Heidi. Article 4. Section 4.01.
Manager, municipal manager. A municipal manager shall be appointed by the council. This appointment shall be made after reviewing the qualifications and job description as drawn up by the council. A majority vote of the members elected to council shall be required for the appointment of the municipal manager, hereafter referred to as manager.
Okay. So the purpose for that is to state who the municipal manager is and who appoints them, or how they come to be. Any comments about it? Stated pretty clearly, and it needs to be in there, and it seems to be current with current practices as well. Trish, you want to go on with number 02?
Qualifications of manager. The manager shall be appointed solely on the basis of executive and administrative qualifications and need not be a resident of the municipality at the time of appointment, but shall become a full-time resident of the municipality within 12 months after appointment unless residence outside the municipality is approved by a majority vote of the members of council. And that.
So the purpose of that is to state, the qualifications of the manager as far as where they're living. And we already know that that is something that we need to look at and make a change in there, because it was brought to our attention by both Jeff and Yvonne when they visited us. So let's star that or highlight it, whatever you're doing, and we will come back to those. Okay. Thad, you want to go on?
The manager shall designate by letter, which shall be on file at all times with the clerk of council, any qualified administrative officer of the municipality to perform the powers, duties, and functions of the manager during a temporary absence from the municipality or during disability. Such designation shall not be effective until the council has approved it by a majority vote of the members of council, and the council may revoke such designation by a majority vote of members thereof. If the designation has not been made and the manager is absent from the municipality or unable to perform the duties to make such designation, the council may by motion appoint any qualified administrative officer of the municipality to perform the powers, duties, and functions of the manager until the return of the manager to the municipality or the disability ceases. The acting manager so designated shall exercise all powers, duties, and functions of the manager during this temporary absence from the municipality or disability of the manager.
Okay. So that states what should happen if the manager is not present or is unable to perform their duties, right?
It goes on to the next page. I think.
That's, yeah, B.
That's B,
Yeah,
okay.
you wanna do that one too, I guess?
Okay. In the event of a vacancy in the office of manager, the council may designate a person as acting manager who shall exercise all powers, duties, and functions of the manager until such time as the manager is appointed.
Okay, good. And we know that that is something that may need clarification, that was brought to our attention. Anything else about that?
Yeah, B, we might wanna put in there, that, it says that the council may designate a person, it might say, put in there by majority vote, maybe, make it consistent with the rest of the section.
Okay,
Or just clean it up a bit.
okay. Okay. Any other comments on that one? Section 4.04, mayor and council relation to manager. Except as provided by this charter, neither the mayor nor the council, nor any member or committee thereof shall give orders to any employees of the manager, either publicly or privately, unless the employee is assigned said duties, and such orders are approved in writing by the manager or noted in a job description. This provision shall not apply to the clerk of courts, clerk of council, and law director. Any council member or the mayor found in violation of this provision shall be subject to provisions of section 8.03 of this charter. It really lines out pretty clearly the relationship between the mayor and council, the mayor and council's relationship to the manager, and limits their power to step in and micromanage anybody over the manager. Any other comments about that? It's pretty clear.
Well, it's clear, it just seems out of place to me.
I think it's necessary, and the reason is this, you have a mayor, the mayor by law, Ohio by schools, has certain authority. And potentially, unless you clarify it, you may have a conflict between the manager and the mayor. It just makes it easier, if there is a question, you look at the charter and there it is.
Well,
Now
it's
maybe
saying-
Dave may have some more to enlighten us on, because you've
well,
worn the hat of manager before.
Yeah,
Well, it's shall give orders to any employees of the manager. I take that to mean if I'm a council member and I've got a pothole on my street, I can't walk in and say to somebody, you go ahead and fix my pothole.
Right.
yeah.
Yeah.
So
You can go-
how
you can
how
go-
is that under mayor and council relation to manager?
Well, if a councilman comes in, or if a councilman goes to a police officer and tells him to do something, or goes to a service department employee, tells him to do something, they really can't do that. They have to go through the manager.
I don't have a problem with the concept, I'm
Okay.
thinking it's simply titled wrong.
Or maybe
It's
it
saying
belongs in
relation.
another place.
Yeah, it's saying
in a-
relation to manager.
It needs to be
and
said,
it's
but maybe in a
talking
different,
about other city employees.
under a different title,
Yeah, I don't know.
someplace else.
Well, no, because it has here about the manager and all the qualifications, and then who's in charge if the manager isn't there. but it's also pointing out that the mayor and council cannot usurp the powers of the manager without it being in writing and approved by the manager. In other words, they can't do an end run around the manager or misuse their powers. It's sort of, and then it goes on about the duties and powers of the manager themselves, that person themselves.
By charter, we set up, by this charter, unless we wanna change the charter, we've set up a city manager type of government. And, to be consistent with that, we wanna make sure that that's the way it is, and this would help ensure that, in my opinion, and someone else may think differently.
We'll pay attention to that when we get to 8.03 back there, because that's how to take care of disciplining them.
That's the firing squad.
Yeah,
So do we wanna go back to that one?
not right now.
No.
I mean, do you want me to mark it?
Maybe just say, double check this, or put
Maybe
a note at 8.03.
change the title to relation to managers' subordinates.
And I suspect in most charter cities that have a city manager form of government, you're gonna have language similar to this in the charter somewhere.
I'm sure they probably do.
It's a semantic issue, but
Yeah.
we've certainly spent enough time on it.
Okay. Dave?
Section 405, powers and duties of the manager. The manager shall be the chief executive and administrative officer of the municipality. The manager shall be responsible to council for the administration of the municipality. The manager shall have the following powers and duties. A, manager shall appoint, and when manager deems it necessary, suspend, remove, or otherwise discipline all municipal employees and administrative officers appointed by the manager, except as provided or pursuant to this charter. The manager may authorize any administrative officer who is appointed by the manager to exercise these powers with respect to subordinates in that officer's department, office, or agency. B, the manager shall direct and supervise the administration of all departments, offices, and agencies of the municipality, except as otherwise provided by this charter. C, the manager shall attend all council meetings and shall have the right to take part in discussion but may not vote. D, the manager shall see that all laws, provisions of this charter, and ordinances and resolutions of the council imposing duties on the manager or employees subject to the manager's direction and supervision are faithfully executed. E, the manager shall prepare and submit to council the annual budget and capital program. F, the manager shall submit to council and make available to the public a complete report on the finances and administrative activities of the municipality as of the end of each fiscal year. G, the manager shall make such other reports as council may require concerning the operations of municipal departments, offices, boards, commissions, and agencies subject to the manager's direction and supervision. H, the manager shall appoint, with the approval of council, special citizens advisory committees and shall discharge when, in the manager's judgment and with council's approval, their function has been completely served. I, the manager may serve as an ex officio member of all boards and commissions which are authorized under this charter and or subsequently created by council. J, the manager shall keep council fully advised as to the financial condition and future operating and capital needs of the municipality and make such recommendations to council concerning the affairs of the municipality as the manager deems desirable or as requested by council. K, the manager shall require reports and information of subordinate officers and employees of the municipality as the manager deems necessary in the orderly operation of the municipality, or when required to do so by council or any board or commission of the municipality. L, the manager shall have the power to appoint, with approval of council, the municipal engineer, the finance director, and the police chief, or any other administrative officers as approved by council. M, the manager shall be the contracting officer of the municipality and shall award and execute contracts and agreements on behalf of the municipality in the manner under the procedures required by this charter. N, the manager shall perform the duties and have the powers as conferred or required by this charter by any ordinance or resolution of the council or by the laws of the state of Ohio.
Okay. purpose of this one?
Covers what the manager's supposed to do.
Right, all the duties and powers, okay. Is it pretty clear? Clearly stated?
I think so.
And it seems current with present practices?
Hope so.
And it is necessary, I would say definitely. Yeah.
And Yvonne didn't suggest anything else to be added or taken away in there.
Okay, Mick?
Section 406, removal of municipal manager from office. The council may remove the manager from office in accordance with the following procedures. A, if necessary or convenient, council may suspend the manager with pay pending an investigation council might determine to be necessary. B, council may, by majority vote of its members, regardless of whether there has been an investigation, adopt a resolution of intent which shall state the reasons for removal and may suspend the manager from duty with or without pay for a period not to exceed 30 days. A copy of the resolution shall be delivered to the manager by the law director and clerk of council or clerk of council. C, within 5 days after a copy of the resolution is delivered to the manager may file with the clerk of council a written request for a public hearing. This hearing shall be held at a regular or special council meeting not earlier than 10 days nor later than 20 days after the request is filled. The date of the public hearing shall be set by the mayor. The only notice required shall be that notice required for a special council meeting. The manager may file with the clerk of council a written reply to the resolution of intent not later than 5 days before the hearing. D, the council may adopt a final resolution of removal which may be made effective immediately by a vote of the majority of its members at any time after 5 days from the date when a copy of the resolution of intent was delivered to the manager, if the manager has not requested a public hearing, or at any time after the public hearing if the manager has requested one. E, the decision of the council to suspend or remove the manager shall be in the sole discretion of council. F, if the manager is suspended from duty, the council shall appoint, by vote of a majority of its members, an acting manager until the manager is restored to duty or until council shall appoint a person to the position of manager as provided for under this charter. The acting manager so appointed shall exercise all powers, duties, and functions of the manager under this charter.
Okay, thanks. So this talks about disciplinary and removal process for the municipal manager, who does it, and the steps and the power that the municipal manager has to have another recourse for a public hearing and so on. So it outlines all of that step by step.
In the future, we also add to your list of qualifications, has what we have written in the past had a problem with? Has we've ever had a question with any of these? I kind of think we should have done that from the get-go. I don't think we were picked to write a new charter.
No.
I think sometimes we can cherry pick more than we should.
Right.
And so I was wondering if you get a question, have we ever had a problem with this particular part of the?
Not that I know of. Not that I know of, and that was one reason why we had the law director and Yvonne and the police chief and so on come in, was because I asked them to talk to us about anything that troubled them, was a problem, was awkward. I also gave all the council members and the mayor an opportunity to come in, which they have chosen not to. They have verbally given me a couple things that were already talked to,
Okay.
you know, about so.
The only question I would have is perhaps run it by Jeff Forbes again, whether the time frames we put in there may or may not conform what modern revised code would say. But other than that, the steps I see no problem with.
And just my personal opinion is, I think it's too much stuff. I think, and I argued it when it was originally written, I remember Yeager was insisting on this. But my theory, or my philosophy with managers is they serve at the discretion of council, and if they lose faith from their council members, you know, there's stipulation for them to, in their contract, for a severance, but I don't think they should have all that in
Well, unfortunately.
here. It's in there.
Yeah, if we didn't have it, then it has to go to court, then we have to have a judge tell us whether we should or shouldn't.
I
We got due process all in there, and at least they can't complain they didn't have a chance to have their say.
Yeah.
And the only question I have is the timing on it.
Is the manager under an employment contract, or is it just hired?
No.
There's a separate
Well,
contract for that?
At least I had a contract, I assume the council
They have-
did
they
a
have
contract with the
contract.
bond. Yeah.
Sure, they would have some sort of hiring contract or
Yeah.
whatever,
Yeah,
yeah.
that's typically how they do most managers. And so some
So
towns
that-
have provisions like this, and some it's, you know, not as, I don't think it's spelled out as much as this
So
is.
if there was a conflict between the contract and the charter, law director would need to catch that and eliminate it?
One would hope.
At the time of hire.
Okay.
And usually the contract is, gives the salary, the benefits, and termination clause of some sort.
Start date and the termination.
Yeah.
And exit.
And, I don't know what hers was, but I was like, I eventually got where I was on a 5-year contract. So if they terminated any time within the 5 years, then there was I think a 6 months, severance package or something like that. And then it was renewed or renegotiated, after the time.
This is talking about an appeal process.
Right.
Yeah, I would hope the contract would have some language in it. I've never seen one for the city, but I would hope it would have some language in it that refers at least to the provisions of the charter that would be incorporated by reference. Because otherwise we have a nasty little procedure called, in the Constitution, the right, or the failure of a right for any state to impair contracts already made. Federal government can violate a contract. States can't.
We'll,
Sounds crazy, but that's the way it is.
yeah, I've made a note here about review contracts, and, we've always had the law firm review the contract before it's presented to the candidate for signing, but we'll make note to review those before we would, go roaring past it. Okay. All right, Ken?
Can I first volunteer to read more than one section?
You can read
Because
two, since
I'm-
they really have heavy
I'm
duties.
coming out of winter, I mean,
Yeah.
Right, they were in the
last week I was
page,
gone.
pages were-
It'll come around.
Article 5, Administrative Officials and Departments. 5.01, Conflict of Interest. The laws of the state of Ohio pertaining to interest of municipal officials in contracts and the expenditure of money on behalf of the municipality shall apply to the officers of the municipality. Section 5.02, Law Director. The law director shall be appointed by council. The law director must be an attorney at law admitted to practice in the state of Ohio. The law director's compensation shall be established by ordinance or contract. The law director shall be the legal counsel for the municipality and for all officials and departments thereof, and shall, when requested, give legal opinions in writing. The law director shall represent the municipality in all litigations to which it may be a party, and shall perform such other duties as may be assigned by council and the manager, as well as those imposed by this charter. The law director shall, upon request, prepare all contracts, bonds, and other instruments in writing in which the municipality is concerned. Council shall have the right to select additional legal counsel.
Section 503,
Wait,
duties.
wait just a minute.
Oh, we have to talk about it, okay, yeah.
Are there any comments or questions about that?
The only comment I would have, and I don't think we have a problem now, but I can see a potential problem if for some reason, we have a law director who also happens to be a law director to an adjacent city. And there's always a potential that you have an adjacent city, you could get involved with some kind of contract dispute. Since we have these joint ventures going now between cities, we could have a dispute as far as territory. For example, we have the Green Belt, which is part of the Hamilton County, part of it is the Hamilton County, the park system. And as far as I know, the law director we have here does not represent anybody that's in direct competition with us, or we would create a conflict. But I would think we may wanna look at the fact that preclude that the law director from representing anyone who is an adjacent municipality or governmental entity.
And the conflict of interest section wouldn't address that?
It's nebulous.
Okay.
I just, and I don't think we have a problem now with it,
Well, actually, our law firm represents Forest Park. too.
That might be a problem.
Well, and in some situations where, over the years, and I can't remember exactly what it was, but I know it's happened at least 2 times, where there was a conflict that, in one case where there was an individual who was contemplating suing us or something, but our law firm had, somebody in their firm represented that individual. And our law firm pointed that out to us, and we hired other legal counsel for that situation.
Does it cover us then? Council shall have the right to select
Right, yeah.
additional.
Right.
Yeah, but who pays for that additional counsel? See, we
Well-
didn't create, the city didn't create that conflict.
Well, we would be paying our attorney, doesn't make any
Yeah.
difference,
You're still paying them.
because we pay our attorney in a case like that,
Yeah.
and if we don't use him, we pay somebody else.
I think in a case like that, it might be appropriate for that law firm to back out of both cases. That's generally what happens, at least in the past, where we've seen that. If you find out, and I've been in a larger law firm
Yeah.
before, years ago, and if we find out we have a conflict within the firm, and we find out about it, we have to tell each client, you had to get your own lawyer because of any
Yeah.
appearance of a conflict.
Well, and they may have done that, because
Mhm.
nobody from their firm represented that person, come to think of it.
Yeah.
We'll
And that's
double
generally
check
what good
Yeah.
practice among the law firm,
Mhm.
they'll back out on both sides if they know about it.
Yeah.
But I just
Yeah.
thought you might wanna put something in there.
We'll double check that.
And this made me think of one thing under the manager's position, and something to consider. Talks about the law director's compensation vote shall be established by ordinance or contract. We have nothing like that in there under the manager's position. Do we need something like that? I've never thought of that before.
Well, I think the law director is always considered to be somebody of an independent
Yeah.
contractor though.
Yeah.
Whereas the city manager is kind of an employee of the
Yeah.
village.
Okay.
Mhm.
Although, so we
Yeah.
can discuss it either way.
Yeah. No, I don't have any hard fast feelings.
Okay. Trish, or Heidi, you were chomping at the bit.
Right, I
Let's
was
go.
asking. Duties of the clerk of council. The clerk of council shall be appointed by council. Council shall establish the salary of the clerk of council by ordinance. The clerk of council may hold other offices or positions of employment in the municipality. The clerk of council shall have those powers, duties, and functions as are provided in the charter by the rules of the council or by ordinance or resolution. Included in the duties of the clerk of council shall be the maintenance of the record of proceedings of the council and a record of all ordinances and resolutions adopted by the council. The clerk of council shall give notice of regular and special meetings of the council to its members and to the public as may be provided by this charter. By the rules of the council or by ordinances or resolutions, the manager may appoint any person as acting clerk of council to serve in the event of a vacancy in the office or of temporary absence or disability of the clerk of council.
Okay,
Who is our clerk of council?
Kathy Lives,
Okay.
she was hired for council. Any concerns, comments on that one? It's laid out pretty clear.
Just, has there ever been any problems with what you've just been written
Putting oaths up.
I think we've only had 3 clerks of council in the last almost 40 years, something like that.
Must be a good job.
Well,
I don't want any part of it.
No, it's a rotten job.
It was until they started these public information requests.
Well, even that, it's.
Well, and as a result of that, we had to
Tedious
raise her
paper.
salary too, because the clerk used to make like $2,000
Yeah.
a year.
Wow.
And now, because they're spending so much time, I don't know what she gets now, but I know when I came back in 2010, we bumped her salary up because she was spending so much time here.
Yeah, the last request, they estimated what, about 40, I think it was gonna take 49 hours to complete
So
all of it.
it's
man.
getting a
That's all they were doing today when I was here.
Yeah, well, and so she's spending a lot more hours here and, it's costing us a lot more. Okay. Trish, you wanna go on?
5.04, duties of the clerk of courts. The clerk of courts shall be appointed by the manager with the approval of the mayor. Council shall establish the salary of the clerk of courts by ordinance. Clerk of courts may hold other office or position of employment in the municipality. The clerk shall perform all clerical duties related to the mayor's court, collection and receipt of fines and costs assessed by the court, keeping of records related thereto, and other clerical duties as assigned. The manager may appoint any person as an acting clerk of courts to serve in the event of a vacancy in the office or of temporary absence or disability of the clerk of courts.
Okay. Any concerns or questions around that one?
Just clean up of, some of the things like mayor's court, which doesn't exist anymore.
Unless it would come back.
Well, I don't know.
Yeah.
Well, and she still has to handle the magistrate's court.
Okay, I think
Which is
I would
instead of
just-
the mayor's court.
Yeah.
I would just, think if it's worthwhile changing the wording of the mayor's court, it doesn't exist anymore.
You could ask Jeff that, but I think they still call it mayor's court.
I think they probably do, because the magistrate is hired in place of a mayor
Yeah.
to handle.
Is it pretty much the same thing, except instead of the mayor doing it, this
Mhm.
magistrate is the one in charge?
Yeah.
Yeah.
It's a bit complicated. It's by statute, we have a mayor's court, and it's Ohio statute. And for years, the mayor ran it,
I'm not hung up with this at all, so that's fine.
okay?
Okay.
Remember, the last time I went by a pharmacy,
Okay, Thad, section 505.
again, already? All right, Department of Finance, Finance Director. There shall be a Department of Finance, the head of which shall be the Finance Director. The Finance Director shall be appointed by a manager, subject to the approval of the majority of the members of council. A, in such case where there is a vacancy in the office of Finance Director, the manager shall occupy the position until such time as someone is appointed to fill such vacancy, but will receive no additional compensation. B, the Finance Director shall be appointed by the manager considering all relevant factors, including education, experience in the field of accounting, taxation, budgeting, and finance. C, the Finance Director shall be the chief fiscal officer of the municipality. The Finance Director shall have authority over and shall be required to keep finance records of the municipality exhibiting accurate statements of all monies received, expended, and encumbered, of all property owned by the municipality, and of all taxes and assessments. The Finance Director shall advise the manager concerning the financial condition of the municipality, and shall examine all payrolls, bills, and other claims against the municipality, and shall issue no warrant unless the Finance Director finds that the claim is in proper form, correctly computed, duly approved, and that an appropriation has been made thereof. The finance director shall collect all monies due to the, and payable to the municipality, and shall be the custodian of all public money of the municipality, and shall disperse the same as may be required by law or ordinance. The finance director shall examine and audit the accounts of all other officers, employees, departments, boards, and commissions, and shall assist the manager in the preparation and submission of appropriation measures, estimates, budgets, and other financial matters. The finance director shall perform all other duties now or hereafter imposed on auditors, treasurers, and tax commissioners under the laws of the state of Ohio. The finance director shall also perform such other duties inconsistent with his or her office as may be required by this charter, by state statutes, by ordinance, or resolution of council, or as directed by the manager.
Okay. Lines out pretty clearly the Department of Finance and the finance director's role, and who appoints and who they report to. Comments, questions, concerns?
Yeah.
I think this is the first gender reference with his or her office, so we can probably clean that up. It's not a big point, but.
Mm-hmm.
Which section was that in?
5.05.
Right, which,
The
A, B, C?
second to the last sentence.
Oh, his or her office.
Mm-hmm.
Or to be consistent, we can make the manager his,
I was kind of paying attention to see if there's any need to make any changes since we are not collecting our own taxes now. And, you know, it looks like it's sort of still okay because the finance director is responsible for managing all of that.
Yeah,
So I don't think that it needs to change.
yeah.
But
If
we-
Rita ever goes away.
Yeah, I was gonna say, but with
Yeah.
Rita doing the collection and managing all the tax part, but it doesn't seem like it doesn't, that it's needing to change.
Yeah, that's even gonna get more complicated, because now there's a push in the state to have the state of Ohio collect all municipal income taxes on behalf of the cities, then give it back to us after a charge.
They're cut, right, exactly.
They want it off the top.
And they're also trying to make all uniform, all the income tax laws and ordinances in the state of Ohio uniform. For example, retirees and Social Security is not taxed by, as far as I know, by Greenhills.
Right, it isn't.
But it is in Wyoming and other places. If they change the state law, all of a sudden, all of that will become taxable under Greenhills stat. So things are happening, and you might want to.
conversely, when I make a contribution to my 401K, Greenhills ignores it.
Yeah.
They still count that as income, even though federal deducts it from income.
So,
You have to retire here to get the real benefit.
That's it, it's a trap.
But then, if you'll remember, he also wasn't very confident that this was gonna pass either. So I don't know if we should worry about.
whether it passes or not depends on how badly the state needs the money.
Well, yeah, we
All
can't,
I'm
we
just saying
can't
is
change
his
it.
lawyers didn't seem to be very,
The only other thought I had on this section is there's later reference to the tax commissioner as if it's an independent body. So I think when we get to that section,
Yeah,
maybe we just delegate it to the finance director.
I would just like to see Jeff look over it in a little bit more detail. Why? Because there has been a change in the Ohio statutes dealing with finance officers. I'm not an expert on it, so I don't know whether that would be enough change to affect what's in here, or what we have in there may be all right.
okay.
I'm certainly not gonna suggest anything, but I think perhaps Jeff might wanna look at it.
Okay, good. All right, moving right along, section 5.06 budget. In each fiscal year, which shall be the calendar year from January 1st through December 31st, the manager and the finance director shall prepare and submit to council a budget for the following fiscal year. The budget shall be submitted to the council on or before the first day of June. It shall include an estimate of all expenditures which will be necessary for the operation of the municipality during the following fiscal year, and an estimate of all revenue which will be received for that period. The council shall approve or amend the budget as submitted and shall adopt same by resolution after a public hearing of which at least 10 days' notice is given in a manner prescribed for the publication of ordinances. Council shall submit the adopted budget to the County Budget Commission on or before the date established by the County Budget Commission. The budget shall be in the form prescribed by the Office of Inspection and Supervision of Public Offices of the State of Ohio, except to the extent that modification is required by any provision of this charter, and all proceedings regarding the adoption of an annual budget not specifically provided for in this section shall be in accordance with the provisions of the Ohio Revised Code. Okay, this is one that was earmarked because it has caused a lot of question in the past, and the reason, and rarely, if ever, do we get the figures from the county to be able to put the proposed budget together before the first day of June. It's usually more like later in July, and so that's something that is gonna need to be changed, or it's best to change it, because the way it's stated here is impossible for anybody to abide by it. And then on down, where it says council shall submit the adopted budget to the County Budget Commission on or before the date established by the County Budget Commission. That seems so, like, so unnecessary to say it, but, because you do abide by that, but I think it probably does need to be in there, so.
And possibly, versus picking the first day of June, the first day of August, or something like that. Some kind of a statement that shall be submitted to council before the date established by the County Budget Commission,
Yeah.
something like that.
Mm-hmm.
Yeah, I was wondering, I talked to someone from council, and I can't remember who it was, and it wasn't one of my relatives. They thought maybe September 1st might be a better date, because it's usually by that time, regardless of what happens downtown, they got it in. But everyone agrees June is totally unrealistic.
Yeah, today,
I would suggest making it maybe 60 days prior to the submission date to the County Budget Commission. You know, getting away from a firm calendar date.
yeah. The problem is, the county sets a date when you have to have it in, but they only get the information out to you maybe 2 weeks before that date, or 30 days before that date, for you to put your budget together.
So 15 days would make more sense than 60.
Yeah, probably, and
Yeah.
we'd need to definitely ask the finance person how that's been running the last couple years. Yeah, sometimes the county is very frustrating to deal with, some things like this,
And
because they establish what kind of funds we're going to be getting for our levies and that sort of thing. We can't just guess.
where it uses the phrase, public hearing of which at least 10 days notice is given in a manner prescribed for the publication of ordinances.
Referring to how many days the notice has to be posted is
Yeah,
what that references.
so we're back into 2.06 and
The only thing we suggested there, I think, was the
15
possible
days.
email, or the, website
Yeah,
edition. Other than that, I think we had, 5 ways to do it, and then we added the
Yeah.
possible.
well, I'm questioning the timing
Yeah,
again. If it's saying 10 days notice, and if we flip back to 2.06, clerk shall cause each ordinance adopted to be published in at least one of the following manners. One is for a period of 15 days. One is simply getting it into a newspaper. Yeah,
And I
what
think we
I'm
did say it
struggling
should
with,
be online also.
it's not well defined, what in a manner prescribed for the publication of ordinances means.
well, the only thing I would say is if if we wanted to put in parentheses, reference, you know, this 2.06, maybe, but,
I think in the event of a potential conflict, this would control as far as the budget is concerned. The 10 days period would control.
And normally what we did, when Kathy handled it, is we ran it in the journal, the announcement. At the same time we announced when the public hearing would be, we announced that, the budget at that time would be available. So the budget was available for review 10 days before the council meetings and the public hearing on it also.
Just remember, the journal, it comes out once a month though.
Yeah, well, we always had to
jockey it around.
jockey that around so we could get one in to let people know when
I'm
the
thinking
hearing
there
would
was,
be.
there was a problem with it a couple of years ago.
Yeah, well,
Back when the, by June first wasn't
right,
recognized
yeah,
Yeah.
by
because, and that was
finance
because the county, and I don't know if the county had changed then or they changed a couple years before that, but the county had changed when they were getting the information out to you. So we couldn't meet that June date anymore because we didn't have, the county wasn't up to
Mhm.
speed. And the county could have changed because of state law change, I'm not sure where it was.
I think they're running into a problem because now they have to appraise the property more frequently. And obviously, they can't calculate what your income's going to be until they know what the appraised value of all your property is. And if you have, say, you're one of the municipalities running through a reappraisal sequentially, until they get what the new appraisal is. For example, the last appraisals, everyone went down, I think, just about.
Oh, it did.
And
Yeah.
until they get that, they don't know what the income of
Right.
10 mills is gonna be.
Mhm. It seems like that change occurred when Jane was here. I mean, that,
Yeah.
that we really started, it wasn't a problem much before that. Then that would be the last 5 years.
Yeah, yeah.
There used to be an appraisal once every 6 years, now there's a mini appraisal every 3 years and a major one every 6 years.
Yeah.
That means you're constantly spinning around in the auditor's office.
Mhm.
With less people. Okay, well, I think this is
Okay,
something we need
well, we
Jeff
need to
to
come
clean it
back
up.
and we'll have Jeff review this too and, okay,
My turn,
yeah, your turn. Appropriations.
okay. 5.07 appropriations. The annual appropriations ordinance shall be prepared by the manager and the finance director of the municipality in the form prescribed by the general law based upon the revised budget as approved by Hamilton County Budget Commission and the official certificate of estimated resources or amendments thereof as issued by the county auditor. The proposed appropriations ordinance shall be submitted to the council as soon as practical after the issuance of such certification of estimates resources. On or about the first day of each year, council shall pass an appropriations ordinance based upon such proposed appropriation ordinances submitted by the manager and the finance director, amended or revised as it sees fit. If it desires to postpone the passage of the annual appropriations ordinance until an amended certificate is received from the county auditor based upon actual balances, council may pass a temporary appropriations ordinance for the first meeting, the ordinary expenses of the municipality until not later than the first day of April of the current year. And the appropriations made therein shall be chargeable to appropriations in the annual appropriations ordinance for that fiscal year when passed. For the purpose of meeting the actual requirements of the municipality as they appear as the fiscal year progresses, council may pass such supplemental appropriation ordinances as it deems necessary, adjusting the appropriations between the various appropriation funds. The total amount appropriated for any fiscal year shall not exceed the total balances carried over from the previous fiscal year, plus the estimated revenue for the current fiscal year, as both such sums appear upon the latest issued certificate of resources. No amending or supplemental appropriation ordinance shall be required to be published. Such ordinances shall be effective immediately. got appropriation in there a lot.
I was gonna say, boy, does that sound like a gobbledygook. I mean, it
Glad you
seems,
said that, it was.
it seems like there should be a more clear way of saying
It's
all
only
of that.
money.
Yeah.
Of saying all of that, or, you know, using some adjectives or some, you know, whatever. It's very difficult reading, but,
What's the rationale for no amending or supplemental appropriations ordinance shall be required to be published? Isn't that in conflict with the open meeting and all that jazz?
Well, not open meeting, but,
Or public notice?
public,
Public.
yeah, and I'm not sure. We could ask Jeff. All finance ordinances like this, based upon state law, are effective immediately when you pass them. And I'm not sure if it's because of the size of it that would preclude it. We published, or we posted, rather, the ordinance, but we've never really ever published our ordinances per se. I think they put it on the website now. But we would have, you know, in our 4 or 5 public posting places, we would take that document, which is fairly thick, reduced down in size, and we would post it.
And basically, the supplementals are usually just accounting
Right.
measures going from
Mhm.
one fund to
You're
another.
talking of my life's work.
Yeah, you know,
Yeah.
that are not restricted.
Yeah,
Some funds are restricted, so you can't play with them.
yeah.
But where,
And-
where we have a first reading and a second reading, why would this be exempted from it?
No, I think it still is, it still requires the first and the second reading. It just doesn't have an emergency clause on any financial ordinances or resolutions. And that's just by state law, as I understand it.
we'll ask Jeff about that.
Yeah.
The only thing that goes through my mind is that the people that are working on the appropriations have their heads deep into the books in order to do that. And having sat on the finance committee as the backup person for 6 years or something, it makes you crazy, because unless you have a lot of knowledge of where everything is going and why you can move from one fund to another, you know, I don't know that the average public citizen, even though they have a right to look at it, would understand any of it. You know,
No, I don't think we should be making judgments on the intelligence of the citizens.
no, it isn't, well, it has nothing to do with intelligence, but it has to do with working with those books. You do it, and all the time, and for the amount of time and explanations and work that it takes to stay within all their other regulatory things about different funds within their account. It seems like what it is that they're moving the money in order to keep moving and keep the year going.
Well,
And so it's-
usually we're running out of money in this pool.
Right,
And we've got excess money in this pool,
Right.
so let's move it from one to the other.
right.
But sometimes you
exactly.
can't do that. I mean, you need to know what funds
Yeah,
you're
there's
able
some-
to
there's
some
move
that
it
you
around
cannot.
from
The
and
That's like-
recreation fund, the
Yeah.
street fund.
The voted funds,
Right,
You
you need a
have
background
to
in
be-
finances and
yeah.
so I think,
But
before
all,
you could do a job
all
like
of
that.
the, all of them do require the 2 readings and going through the
Mhm.
regular
Okay.
system. It's just that it
You
doesn't.
don't have to make
Public
it
accounting
public
is a
or no
different
public,
animal.
doesn't have to be.
Even the accountants look, it's a specialty area. Some accountants do public accounting, don't do any other kind of accounting. It's so specialized, because you're dealing with strictly cash flow. You
You're
don't have-
talking to one of them.
Yeah, so
Now, all the cities,
I
It's
agree.
very tedious, I don't think I
yeah,
could.
all the government
do a
agencies,
job.
I
and
have a
think we
rule
go
when I'm
on GAAP
talking to the board
accounting
of
now.
directors,
Aren't we
as
on
soon as
GAAP?
3 of
I
them
think
fall
so.
asleep, I shut up.
I think all government agencies, or just about all of them now, are on GAAP accounting. And it started with the big cities and townships, and then it's worked its way down, and I think we just switched to it in the last 2 or 3 years, 4 years maybe. Okay.
Okay, all right, section 5.08, Nick.
Contracts and purchasing.
Woo-hoo.
A, the manager shall be the contracting officer of the municipality and shall execute all contracts and agreements on behalf of the municipality in the manner and under the procedures provided by this charter. B, when the expenditure of funds for the purpose of supplies, equipment, or materials, or to provide labor for any work to be performed under a contract for a public improvement exceeds the amount specified by the laws of the state of Ohio for which such purchases or work may be accomplished without advertisement and competitive bidding, such expenditure shall first be authorized and directed by an ordinance passed by council. The manager may award a written contract to the lowest and best bidder after advertisements on the same day of each week, but not less than 2 nor more than 4 consecutive weeks in a newspaper determined by the council to be a circulation within the municipality. C, compensations of person and employees, contracts with persons, firms, or companies for services requiring specialized or professional skill, knowledge, or training, expenditure for and contracts for insurance and expenditures required because of a real and present emergency, when authorized by an ordinance adopted by the affirmative vote of at least a majority of all members of council, may be awarded and executed without the necessity of advertisement and competitive bidding. D, modifications and changes to contracts awarded under competitive bidding, which modifications and changes increase the total expenditure by an amount which would itself require advertisements and competitive bidding under this charter thereof, shall be authorized by an ordinance enacted by the council. However, an advertisement and competitive bidding shall not be required. And E, no contract or order shall be willfully split or divided into separate contracts or orders solely in order to avoid the requirements of advertisement and competitive bidding as provided by subsection B hereof.
Okay. All right. Comments?
The first time I read that, why wouldn't we require, competitive bidding?
Well, it has to do with the size of the contract. If it's smaller contracts, it's mainly so that business can flow. If it's big jobs,
Right.
you know.
It kind
to
of
certain
follows the
degrees.
state law.
Yeah.
The state, I think, requires competitive bidding over $10,000.
Mhm.
Oh,
I
okay.
think they amended, didn't they, to 25?
Is it 25 now? Could
They've
be.
changed it. Yeah, I didn't know what the number was, but they.
Oh, so this
would
would be
wrong.
anything
Gave up.
less than that?
Yeah.
Yeah,
Okay.
yeah.
And so normally what you do for less ones is you go, depending on what it is.
Right.
You might get quotes from
Mhm.
some people. So if you're gonna do a roofing job and it's only $4,000 or $5,000, you'll ask a couple of different roofers to submit a proposal.
But if it was something, and I don't know if this even applies to like garbage collection or something like that.
That's
Yeah.
competitively bid.
Yeah, okay, something big.
Yeah.
The last